Generally, no. It's not that your child is not going to do what you want them to do, or is dishonest, or is going to change the plan, although we see that occasionally. It's more that things can happen to derail that informal plan. You know, we have some people who come in and say, I have my oldest son joint on all of my bank accounts, so the oldest son is going to get everything, and mom assumes that he's going to split it up with his siblings after mom passes, and he may. But there are things that can derail that, like if he's in a divorce, or he gets into a car accident and has a creditor, or passes, and those assets immediately go to his wife or his children through his will or estate plan, and we lose them. And that's not a place that mom intended them to go. One example is in the context of special needs. We see families a lot of times who will say, I have a special needs child, I don't want to leave assets to him or her directly. It may knock them off their needs-based benefits. So I'm going to leave them to oldest son or daughter, or the good child, and he or she will take care of my special needs child. And that may work, but it may be complicated, as we've discussed. The better way to do that is to leave those assets for the special needs child in a special needs trust, and name the other child as the trustee in charge of the purse strings. That way, if something happens to the trustee, to the oldest child, let's say, if they get a divorce or a car accident or a failed business or credit card debt, or they pass away, there's a successor trustee. Someone else steps in and takes the reins, and the plan continues to make sure that they stay on their benefits and you don't need to disinherit that child.